Good morning. Today is Tuesday, October the 16th, 2018. My name is John Richardson. I'm speaking to you from Toronto, Canada, and this is a continuation of my series of having to do with Americans abroad and what they're going to do with their U.S. citizenship, which is becoming more and more problematic. And I have a fabulous return guest today. Virginia Torre Jeker is joining us from Dubai again. And, you know, I mentioned that the purpose of this series of videos is to talk about U.S. citizenship, what they're going to do with that. And today our theme is we're going to talk a little bit about U.S. citizenship. And, you know, U.S. citizenship is so fabulous that, in fact, every U.S. citizen is automatically a dual citizen, which you'll find out in our discussion with Virginia. So here we go. Virginia, how are you?
I'm doing great, John. How are you today?
I am absolutely excited to talk about this topic with you because
it's a very good topic, I must say.
It makes me feel like, you know, when they say that U.S. citizenship is the greatest, the bestest, I mean, we can actually explain why, because all U.S. citizens are born dual citizens now. I mean, it's just
they don't realize it, though.
They don't realize it, but you know, this is a benefit. Clearly, well, at least from some perspective. So, we're talking. Why would they be dual citizens from birth? What kinds of citizenship do U.S. citizens actually have? What do you think?
Okay, I think it comes as a surprise to many people to learn that even though the United States is one country, it has two forms of citizenship. And one form, you can reap a lot of benefits, while the other form makes you bear fiscal burdens. So the first form of citizenship is the kind that you're given under the immigration and nationality laws, your U.S. citizenship. The other form of citizenship is what we call tax citizenship. You can become a tax citizen, of course, if you're a U.S. citizen, allowed to enter the U.S. freely with a passport, or, you know, just as a normal, regular U.S. citizen. But your tax citizenship can apply even if you're not treated as a citizen, a U.S. citizen for immigration law purposes.
So just
so those
for a minute.
Unfortunate people have the
clarity.
issue of all the fiscal burdens.
So to get clarity, you could actually be in a position where you would not have the first kind of citizenship for immigration or nationality purposes, but could still be treated as a tax citizen? Have I got that right?
Yes, you have, John.
So in other words, you could show up at the U.S. border, and they could say, no, you're not a citizen. We're going to not let you in the country, but then send you into the next room, IRS Treasury, and they would say, but you have to pay U.S. taxes anyway?
That's right, because you will, under certain circumstances that we will be talking about today, be treated as a tax citizen.
Is there any other country
even though you're not an immigration and nationality law type of citizen. That's the two citizenships. We have two separate and distinct sets of laws that people don't seem to understand. They think, well, I gave up my citizenship, or I gave up my green card. I shouldn't have to pay any U.S. taxes. I'm not, a tax citizen anymore. Not true, unless you've done everything correctly.
Wow.
To get rid of your citizenship.
All right. Well, let's break this down one citizenship at a time. So let's begin with a
good idea.
Yeah, one citizenship at a time. So let's begin talking about U.S. citizenship for nationality or immigration purposes. So, what is it that makes somebody a U.S. citizen for nationality or immigration purposes, anyway?
That's a very good question, John, and it's actually not that simple to answer, because various rules will determine whether you are a U.S. citizen for immigration and nationality purposes. For example, the 14th Amendment to the U.S. Constitution, the Citizenship Clause, is one area that gives us the answer. Then we have the U.S. Immigration and Nationality Act, the INA, and then we have decisions of the U.S. Supreme Court superimposed on all of that. And on top of that, we have something called the common law principle of jus soli, which is Latin for law of the soil. So when you look at the conglomeration of all of these different sources of law, that is what will determine U.S. citizenship. A simple example that most people are familiar with is the common law principle of jus soli, the law of the soil. When an individual is born within the United States, he's automatically acquired U.S. citizenship. Whether he wants it or not is irrelevant. And the U.S. is one of only about 30 countries that applies this principle. And you may be familiar that many people from different countries believed, oh, U.S. citizenship is the best in the world. I'm going to fly over from Lebanon or wherever, Asia, some Asian country, and I'm going to give birth to my child in America because then he will have American citizenship. Well, a lot of people did that. And then a few days after the birth of the child, they returned to their home country, and the child has now grown up and is a U.S. citizen with all of the attendant issues of being a U.S. citizen, including taxation on his worldwide income and so forth. So that is one common way people receive U.S. citizenship. The other way is if they are born overseas, when at least one parent was a U.S. citizen, and that American parent lived in the United States for a certain period of time. And once that time qualification is met, even though the child is born abroad and his other parent is not a U.S. citizen, the child will acquire U.S. citizenship. And there are many other ways it can be acquired, certain rules that I'm not very familiar with because this is not my area of law to be an immigration attorney. But those are the two I'm most familiar with.
Okay, so all right, so you're describing two mechanisms for citizenship by birth. We probably should add there's citizenship by naturalization as well. So, somebody gets a green card. But okay, so now...
And one other thing I want to add, John, just as an aside, with all the assisted reproductive technology we have today, people have to be very careful if they're using donated sperm and donated eggs to know the citizenship of that donor, because you can transmit U.S. citizenship
and a tax liability.
Yes, through this assisted reproductive technology. So that's a whole another area, but I just think people should be aware of it because it comes as a surprise to many that when at least one of the biological parents is an American citizen, that the citizenship can be transmitted. That's the rules they have under the State Department now.
My God, extraordinary. So on the most basic level, what you're saying, and I believe this is clearly true, is that if somebody's born in the United States, they start off life as an American citizen for sure, but there is this whole fascinating law of relinquishment. It is possible to relinquish U.S. citizenship for nationality purposes. Briefly, because this is so incredibly complex, and we could talk about this for 3 months, but briefly, what would be ways that people could relinquish U.S. citizenship, having been born in the United States?
The ways you can relinquish it if you're born in the United States is either renouncing your U.S. citizenship, which is a very special procedure where you go to the U.S. consulate or embassy outside of the U.S., and you take an oath of renunciation. The other method is by something called an expatriating act. You commit what is a potentially expatriating act with the intent of wanting to give up and relinquish your U.S. citizenship. And the expatriating acts have changed over time, but the general ones are, for example, if you take on the nationality of another country, and again, you must do so with the intent to give up your U.S. citizenship. Merely taking on the nationality of another country is not sufficient in and of itself. You've got to intend to want to give up your U.S. citizenship when you do that. Other forms of expatriating acts can be working at certain levels in a foreign government or serving in the army, the forces of another foreign government. And I believe if you take certain oaths of allegiance to a foreign country, that is another potentially expatriating act.
Right. Now, Before we get into the tax citizenship thing, one of the things that I think is important for people to understand about the relinquishment for nationality purposes is that there's no specific requirement in the law that somebody who relinquishes citizenship has to notify the State Department, correct? In other words, a CLN.
That's correct.
Yeah, a certificate of
As far
loss
as
of
the immigration
nationality.
side goes, I think that is correct.
Yeah, it is correct, yeah. So, in other words, to lose citizenship for nationality purposes, a certificate of loss of nationality is actually not required. So, for many years, to transition to the tax citizenship thing, for many years, people would lose their citizenship for nationality purposes and simply stop paying U.S. taxes because they were not a U.S. citizen. And we know what the attitude of the U.S. government is, with people who don't pay taxes. It's decidedly negative. So,
Absolutely.
So therefore, in response to this, they created the concept of the tax citizen. And what are your thoughts? Maybe you can explain what tax citizenship is.
Right. Okay, John. It's a very complicated area, as you've kind of alluded to. We never had this concept of a tax citizen before the Tax Act of 2004. And just by way of background, to add on to what you mentioned, in 2003, the Joint Committee on Taxation published the results of certain work that they had been undertaking for a number of years, reviewing the U.S. tax and immigration rules that governed relinquishment of U.S. citizenship and residency, by the way, for green cards, but we're not going there today. We'll just deal with citizenship. So what they found was that because a citizen could give up his U.S. citizenship, for example, by taking an oath of allegiance to a foreign country, and his immigration law status would then cease as a U.S. citizen, that also controlled his federal tax status. He never had to notify the IRS. The IRS would be completely unaware that that person had given up his U.S. citizenship. He would just stop filing tax returns and go on with his life. Of course, the IRS was not happy with this because they said, we have no way of monitoring these people. We don't know if they given up their citizenship for a tax-motivated reason, because we had laws in place under the tax code that said if you've given up your citizenship for a tax-motivated reason, we are going to punish you in some way, shape, or form. And the IRS was without a mechanism to really enforce those laws unless they would know that the person had given up their citizenship. So in 2004, we had the American Jobs Creation Act of 2004 come into being, and you can welcome my cat Max. He's joining the session this evening here.
This
Goodbye.
is extremely interesting stuff. Why wouldn't the cat want to be here?
Exactly. Well, he's actually the tax expert. I just say what he tells me to say. Okay, so in the American Jobs Creation Act of 2004, gave birth to this tax citizen concept, which basically what that law did was it severed the link between an individual's status as a U.S. citizen under the immigration rules from his status as a U.S. tax citizen for purposes of our U.S. tax.
Okay, so just to pause. So that's the moment in time where somebody could now cease to be a citizen for nationality purposes, no right to enter the U.S., but continue to be subject to U.S. worldwide taxation anyway, correct?
That's correct. As hard as that is to believe, that is correct.
Okay, now, perhaps you could go a step further. So in 2004, the concept of the tax citizen is created in a general sense, and I say in a general sense because these laws have, evolved over time, but in a general sense, what was required of an individual who'd lost citizenship for nationality purposes to also lose citizenship for tax purposes? In a general sense, what was required?
Okay. Very importantly, because understanding this will help people understand the later changes in the law that have caused such confusion. Under the 2004 Tax Act, you had to do a couple of things to cease to be treated as a citizen for tax purposes, okay? You would continue to be treated as a tax citizen of the U.S. until you gave notice of the Expatriating Act to the Secretary of State, that would be the State Department, the consulate or embassy in the foreign country where you are, and you had to provide a statement to the IRS.
Okay,
And
so
let's
twin
just call this
notification.
statement Form
Notification.
8854.
So notification to the State Department and notification to Treasury IRS. In other words, separate and distinct notification to two branches of the U.S. government, right?
That's correct,
Okay.
yes.
And failing that, you continue to be subject to worldwide taxation. Is that correct?
That's right.
Oh, my God.
That's right.
Surely
So
this
if
could
you
not be
didn't
true.
know that you should do this, and let's say you went and you took a formal oath of renunciation, like you didn't just commit an expatriating act with the intent to relinquish, like by working in the foreign government. Let's say you went and you took that oath of renunciation at the embassy. You think you're done and dusted. Well, guess what? Uncle Sam still has his hooks on you for your taxes until you do these things.
Right. Well, specifically, if you're renouncing, you're giving notice to the State Department,
Then
but
you
you'd
give
still
it
be
notice
required.
to the Secretary of
Yeah.
State, but you still did notice to the IRS.
Yeah, this is just shocking. Okay, so this went on then, as I understand, from 2004 to 2008. Now, what happened in 2008? First, with respect to the notice requirements, how did they change?
Okay. 2008 was a crazy year. In that year, the HART Act was enacted into law, and the expatriation rules were completely revamped. So expatriation rules were completely replaced, and we have something that is called a concept called the covered expatriate. And in addition to this covered expatriate concept, which we can talk about later, what they said was you will be treated as relinquishing your U.S. citizenship only at the earliest time you give something called, we call it a notice event. So there are 4 different times that could be notice events, and you will be treated as relinquishing your U.S. citizenship on the earliest of the notice event that takes place.
Okay.
In addition to that definition, what they said in another section of the code that was changed with the 2008 HART Act, they said in another section that you will not cease to be treated as a U.S. citizen before the date on which your citizenship is treated as relinquished under that notice event. So in simple terms, you remain a tax citizen until a notice event occurs. And so the important things are understanding what a notice event is.
Okay, or to really break it down, my understanding of this is that if you can figure out how to understand the rules and put them all together, what it really means is that from 2008 on, you're treated as a tax citizen until a CLN, a Certificate of Loss of Nationality, has been issued.
I would say that's the simple answer. But one thing that's important to remember is that, for example, if you give up, you renounce your U.S. citizenship at the consulate or the embassy, let's say you do that on January 3rd, and your CLN, Certificate of Loss of Nationality, is not issued until 6 months later, when do you stop being a tax citizen? On January 3rd or 6 months later when the CLN is issued? The answer is it goes back retroactively to the date you gave up and renounced your citizenship, January 3rd. So while you do need to get the CLN, it has to be, your relinquishment has to be approved by the issuance of the CLN. It is retroactive to the date you actually gave up your citizenship and renounced.
Right. Okay. All right.
And similarly, for someone who has done a relinquishment in one of those other fashions with an expatriating act, with the intent to give up his citizenship at the time he took the act. He also needs to get that certificate of loss of nationality, and he has to submit a form stating he voluntarily gave up his citizenship by performing this act. So that one is a little bit more complicated when you have that kind of situation.
Right. Now,
both of them must be, a certificate of loss of nationality must be issued with respect to both ways of relinquishing your citizenship.
right. So if we compare, going back to your discussion of the 2004 versus the 2008, what seems to me to be coming through from your description is that from 2004 to 2008, there were two notification events required. The State Department, which ultimately would be the CLN, but also a Form 8854 notification to the IRS. From 2008 on, I didn't hear you say that anything other than the CLN is required. In other words, I don't believe the Form 88, the specific notification to the IRS is required anymore to lose citizenship for tax purposes on an ongoing basis.
That's correct. But other bad things will happen to you if you don't submit the Form 8854, the notice to the IRS. So let's just bring people back again and say, okay, in 2008, the expatriation provisions were changed so dramatically, and they have caused such confusion amongst people, including professionals, that it's really hard to keep everything straight. So in 2008, with the HART Act, you are correct, John. You will not need to submit a Form 8854 in order to get rid of your U.S. tax citizenship.
Prospectively.
Submit the form, bad things will still happen.
Right. Okay. So I think we need to be very, very careful with this. Okay. So you don't need to submit a Form 8854 to cease to be a U.S. tax citizen prospectively. But if you don't submit the 8854, there may be bad things that will happen retrospectively. Would that be correct?
Oh, there will be bad things that will happen.
There will be bad things that will happen. Okay. All right. Now, the bad thing would be the exit tax rules, and that's a whole different topic that we can perhaps cover another time. But I'd like to, as we're coming to an end, I'd like to ask you a question here. Which relates to, what was a fabulous sort of dissecting these rules along the way. But in our discussion, we talked about pre-2004, then we talked about 2004 to 2008, then we talked about 2008 on. Let's imagine this scenario for a minute. Let's say that somebody moves to Canada as a Vietnam War type person, or rather lack thereof, and became a Canadian citizen, say in the late 60s, and lost U.S. citizenship. It was never required to get a CLN. Is that person somehow subject to these rules in present-day time?
That's the million-dollar question. I have my view on that.
And what is your view?
My view is that no, he is not required to follow the new rules that came in post-2008. This is an issue of great contention amongst tax professionals, but I believe that if he ceased to be a citizen under the immigration and nationality laws before this 2003, 2004 Act, you said, when did this happen, John? In the 70s or the 80s?
Yeah, the
he became
70s.
A Canadian?
We're large numbers of people.
Never got a CLN. He's done, because under the immigration rules at that time, he was no longer a citizen.
In fact, he may well have been an excludable alien.
That's right.
I mean, amazingly.
Absolutely. He is.
Yeah.
So that person, based on the laws that existed at that time, he has ceased to be not only a U.S. citizen for immigration purposes, but for tax purposes as well.
Yes, I think that's right, because he's out of the system before the tax citizen was even created. There are lawyers, tax professionals who take a contrary view. I think what's important...
They're basing the contrary view, just to be clear, on the poor drafting of the Hard Act provisions that came in 2008. If you try and figure out the language of those sections, I can understand where their position comes from. However, I don't believe that this was at all the intent, and I think that one can interpret the language another way.
Yes.
You and I have actually spoken about this other method of interpretation, and in fact, I believe the courts would overwhelmingly support such an interpretation, because the courts don't like to interpret a statute in a way that doesn't make sense in the gestalt, in the whole.
Sure.
And I think that the attorneys and tax professionals who are viewing it the other way are not looking at the entire
They're not
picture.
looking at it contextually at all. All right. Well, we are out of time for today, and that was another fantastic discussion with you, Virginia. And
Well, thanks, John.
this is, I think, a very nice logical ending point, and we can pick this up, this statute, another time. So thanks very much. And again, this is Virginia Torre Jeker, who's a very well-known U.S. tax lawyer in the world of Americans abroad. You will find her fantastic blog at us-tax.org. So don't forget to check that out. I am John Richardson, and we'll be doing another interview with Virginia. This is great. Thank you very much.
Thanks, Joel. Have a good day over there in Canada.
Okay, thanks a lot.